approve minutes.
Pushed that a while ago.
Oh.
I don't know why I just.
You can vote to approve minutes even if you were not in attendance at the meeting for those minutes. It's kind of a consensus thing where what I read was you're kind of going with the group, and if there's no conflict with anybody saying that things aren't right, that it's fine to vote for that. So going forward, we won't do that awkward step of asking for abstentions because you weren't there. And the other thing I learned, which I think if it's okay with you, is that an efficient way of approving the minutes is for the chair to assume the motion and obtain unanimous consent that the minutes be approved as distributed. We don't have to do the make a motion, raise a hand, and do a vote. I just, and it happens to be me as the chairman, whoever is chairing, can basically say there being no more further corrections, the minutes stand approved as presented or with corrections. So we'll do that. I know we're trying to cut time off. Maybe that'll cut 15 seconds out of our meetings. But with that said, we have the minutes from the November 8, 2021 meeting in our packet. Any corrections, changes? Okay, I don't see, there were no raised hands, were there?
No.
No. Okay. Well, there being no corrections, the minutes will stand approved as presented for the November 8 meeting. Then we also had the November 22nd meeting of 2021. Any changes, corrections that need to be noted or made? Okay.
I do not see any hands.
All right. No corrections noted. The minutes stand approved as presented. Now we'll move to a portion of the meeting that we do every time. This is being broadcast live via Zoom. And we give opportunity for just people, citizens in our community or anywhere actually, to speak to the Planning Commission. You are on Zoom, then just hit the raise hand button and wait for Kelly to recognize you. If you are participating via telephone, dial *9. That will effectively raise your hand and then wait to be recognized. So this is an opportunity for just the general public to speak to the Planning Commission on any matter that is not on tonight's agenda.
And other than the panelists, there's nobody on the meeting tonight.
Nobody here. Okay. Very well then. Let's move right on into our training time, and I will turn it over to you, Kelly, or Chris or whoever.
Yeah, I think just going right to Chris would be fine.
Thank you, Chair and members of the Planning Commission. My name's Chris Crane. I'm with the city's law firm, Beery, Elsner, and Hammond, and I'm one of the land use gurus there. I did this same training last year, so many of you will remember me. But for the new faces, I'm going to try to go through some basics of the what you're likely to face in the upcoming months in terms of public hearings and issues presented to you. For those of you who've been here before and heard this, I apologize. A lot of this is going to be repetition, but if you think I'm missing anything, leaving anything out, if there's something that I didn't emphasize that you think that folks would benefit from emphasizing, please just jump in and let me know, and we'll turn this into more of a discussion than just me talking at you. I also forwarded to Kelly 2 sets of materials. One is like a 24-page treatise on land use planning for local government, and I'm not going to go through that. It's really designed more as a resource for you, a reference document if you have questions about sort of the legal underpinnings of anything. In the sections on like ex parte bias, conflict of interest, we cite a number of cases as examples of the sort of things that come up, but we'll go over some of that tonight as well. That's a topic that people often have questions on, so I want to spend a little bit of time with that. Otherwise, I want to describe briefly the two types of land use decisions that you will be asked to make in your capacity as, well, sort of legal decisions. There are also obviously things like hiring decisions and other things you'll be asked to decide. But in terms of legal decisions, there are two types, and then legislative and quasi-judicial. And then we'll focus primarily on the quasi-judicial land use decisions, because that's the one that tends to generate the most controversy, the most legal questions, and almost any appeal I've ever been involved with involved a quasi-judicial decision. So those get a lot of scrutiny, and it pays to get them right. Okay, Kelly is going to run the projector for me, so I appreciate that. Thank you, Kelly. Yeah.
Do you see the screen share right now?
I can. Can everyone else see it?
Okay.
All right. So as I say, there are two types of decisions, legislative and quasi-judicial. Legislative is making policy for the city. You're writing or deciding, at least making recommendations to the city council, what you think the city's land use regulations should be and what they should say, to the extent the legislature lets you, frankly, but that's another discussion. But in quasi-judicial decisions, the word judicial is not there by accident. You will be effectively acting as a judge to determine a person's property rights under the law. The legislative decision sets the rules for the city. The quasi-judicial decisions then decide or apply those rules to any individual property or development. So you can decide both what the law is going to say and then apply it to individual circumstances. And like a judge, you're not allowed to be biased. Your decision has to be on the record. So it has to be fair. The sort of touchstone of quasi-judicial decision-making in Oregon is that the parties are entitled to an objective decision maker. You have to be able to be objective when you're making these decisions. People also then have to know what information you're basing your decision on. And we'll touch on this in a little bit, a statute, number of them that specifically say your decision has to be based on the evidence in the record and the criteria, the laws that apply to that decision. So that's why things like ex parte communications are prohibited, because if you're talking with people outside of the record, then the other folks, the parties, the applicant, don't know what information your decision is based on. Go ahead, Kelly, we'll jump to the next one. As I mentioned, legislative decisions tend to be big policy decisions. Quasi-judicial decisions, the courts have sort of laid down three criteria. Those are whether a proposal involves only a single property or a small group of properties. The decision is based on pre-existing criteria. You're not allowed to decide whether or not to approve something based on whether you think it's a good idea. You have to approve or deny something based on the criteria that are in your code or other applicable criteria, like state statutes, for example. And then the final criteria is, are you required to make a decision? If the city is looking at, do we want to increase our park requirement standards? That's going to affect every property in the city, and you can always decide to table it and come back to it later. But for quasi-judicial decisions, most of them are subject to what's called the 120-day rule, and the city has to make a decision within a specific period of time. So under those circumstances, it's a quasi-judicial decision, and those are very rule-bound decisions, and we'll get into them. Go ahead, Kelly. The other thing I wanted to bring to your attention, actually two, and I can't remember if I included a slide on the second one, but the first one is this thing called a limited land use decision. It's a type of quasi-judicial decision, typically a land division, such as a partition or a subdivision or a design review application. And what that statute says, the limited land use decision statute, says that a local government has to incorporate into your land use regulations any policies in your comprehensive plan that you want to apply, or you can't apply them. So you can't apply goals or policies from the, whoops, I'm sorry, this was a older slide, from the Sandy comprehensive plan unless the goal or policy has been expressly incorporated into the development code. And put in your development code something that says that, oh, the development has to comply with the standards in our transportation system plan is not enough. So that kind of incorporation by reference is not sufficient. You have to be specific. What parts of your comprehensive plan, including things like your parks master plan, your transportation system plan, those kinds of plans, you have to be specific and put those in your development code, or you cannot apply them. The other thing I wanted to mention is, and you'll hear a lot about this over the next year or two, is the clear and objective standards. If a proposed development is for residential housing, your standards have to be, quote, clear and objective, or you cannot apply them. So between the limited land use decision that requires you to incorporate your comprehensive plan provisions into your land use code and the clear and objective standards requirement, you've absolutely got to base your decision on the code, and those code standards have to be clear and objective when it comes to residential development. Go ahead, Kelly. Those statutes are keeping Kelly up nights, by the way. So here's the statute I referred to earlier, and this is why it's so important to make sure that your decision, again, is based on the standards in the code. This says that approval or denial of a permit application shall be based on standards and criteria which shall be set forth in the development code. So if we don't do that, we're violating the statute. It then goes on to say that approval or denial of the permit application has to be based on and accompanied by a standard or a statement that explains the criteria and the standards you considered relevant, the facts you relied on to render the decision, and the justification for the decision based on those criteria. This is a long way of saying your decision has to be supported by findings. The findings are drafted by staff, but in the end, they're your findings. And so you need to read through them carefully and make sure that you agree with what staff has concluded. And for those of you who've not done this much, what it looks like is, a multi-page memorandum that lists the individual criteria, then describes the evidence in the record, either from the application or maybe from opponents who came and showed up and testified or provided additional information, what evidence applies to that criteria, and then whether the evidence shows that criteria is met or not. So the findings are very important, and for just about every LUBA decision I've ever been involved with, somebody's challenged the findings, saying they weren't sufficient, didn't provide additional or sufficient explanation of the evidence in the record, weren't supported by substantial evidence, and so on. So in any event, at the end of the day, your decision is to approve or deny something based on the findings, and that's how this statute gets implemented. Go ahead, Kelly. Again, going back to the criteria, I feel like I'm a bit of a broken record here for folks old enough to remember that reference. But because I keep coming back to this notion of the criteria in your code, but again and again, the decisions, particularly the controversial decisions you're going to be asked to make, involve the code, and you cannot stray from the standards. So here's another one. This is called the fixed goalpost rule. That's is subsection 3 of this statute, 227.178. And it says that approval or denial of the application shall be based on the standards and criteria that applied to the application at the time the application was submitted. So not only does your decision have to be based on the criteria, those criteria become fixed in place when the date the application is submitted. So it doesn't matter if you might be in the middle of a legislative process and you adopt changes to the code while an application is under review, those changes will not apply to that application because it's vested in the criteria that apply on the date the application was submitted. Unlike the fixed goalpost rule, there's also the 120-day rule that says that the city has to make a final decision on an application for a land use permit within 120 days after the application is deemed complete. And that's the date the application was deemed complete, not the date it was submitted. Because very often applications will come in and they'll be missing relevant information. Staff will go through the application, let the applicant know what else they need to submit. It takes time for that stuff to get submitted. And once it all is then submitted, or the applicant says, yeah, I'm not going to submit anything else, go ahead. On that date, then the application is deemed complete and the 120-day period starts. The 120-day period can be extended, but only by the applicant. So that's important to keep in mind. So 2 dates, the fixed goalpost rule takes effect on the date the application is submitted, the 120-day rule on the date the application is deemed complete. Go ahead, Kelly. And then I mentioned that quasi-judicial decisions are very rule bound, and they are. And the sort of central statute in all of that is this statute, RS 197.797. And it lays out a number of rules that apply to every quasi-judicial hearing. The city has to send out notice to properties within a certain distance. It lists what has to be in that notice. It sets up what has sort of been distilled down to a script that staff prepares for the chair at the beginning of every hearing, in which the chair has to identify the relevant approval criteria and note this raise it or waive it requirement. And briefly on the raise it or waive it requirement, that's a rule that says if you're going to appeal something later on, you have to have raised that issue in the local hearings process. You can't save an issue until you file your your appeal with the Land Use Board of Appeals and raise the issue then. I call it the no ambush rule. So if something is not raised in the local review process, it can't then later be raised on appeal. You have to raise it or waive it. Also, and this will come up a lot because there's a part of the statute that says anyone can ask that the record be held open so that they can submit additional information. Significantly, that provision only applies at the initial evidentiary hearing, which is almost always the Planning Commission. So at first hearing on a subdivision, if somebody asks that the record be held open under this statute, you have to agree, and you have to hold it open for at least 7 days. Then you have to allow an additional 7 days for people to file evidence in response to that. And then at the end of once the record period, once everybody's submitted everything they're going to submit, you can close the record, and the applicant then gets a final 7 days to submit their final written argument. You might hear this referred to as the 777 rule if and when it comes up. It's likely to come up, frankly. And the applicant can waive that final 7-day period for their written argument. And that often happens if the proposal is not controversial. It looks like the Planning Commission is going to go ahead and make a decision. So you can't make a final decision until the record's closed and the applicant has either submitted or waived the 7 days. Then you can proceed to making a decision. And helpfully, staff usually provides a script that describes all this before the hearing gets open. You'll get very tired of hearing this script. Okay, Kelly, what's next? So I mentioned at the beginning that you're effectively a judge, and judges are not allowed to be biased. And the way that LUBA and the courts have defined bias is whether or not you can make an impartial decision based on, state this differently. If your decision was the product of either positive or negative bias rather than an independent review of the facts or the law. The standard is whether you prejudged the application before you sat down and listened to all the evidence, before you looked at the record. If you prejudged the application and you knew how you were going to vote, then you did not make a decision based on the evidence in the record and the applicable criteria. In that case, that's what LUBA looks for in terms of bias, whether or not a decision maker prejudged the application. And I will underscore the fact that it doesn't matter how many of you voted to approve or deny something. If one person is shown to have had bias, LUBA will reverse the decision and send it back, and we get to do it all over again. So if you think that, and frankly, everyone is their own best judge of this. If you think in your own exercise of good faith that you can't be impartial on a decision, then step down. And that's the best way to insulate the decision from later challenge on the basis of bias. This Halverson Mason case out of Depot Bay involved I believe it was a city councilor. There was an application to put a real estate office in the subdivision, and the city councilor went as far as to writing letters to the editor saying there was no way he was going to approve it. And then when the application was submitted, he said, "Oh no, I can be impartial. Well, nobody believed him, and Luba didn't believe him either, and they sent it back down, and the city had to go through the application review process all over again. Oh, go ahead. Looks like the next one describes this a little bit. The city councilor said the applicant didn't have the right to use the structure for the proposed use, and therefore it should be denied. And that was before the application was even submitted. And this gives you an idea of what Luba looks for. They concluded that the city councilor formed an opinion regarding the legality of this real estate office prior to receiving the evidence. It's clear that the councilor prejudged the application and was not capable of rendering an impartial decision. That's what Luba looks for. Go ahead, Kelly. The next one is my favorite example. This one was just way over the top. This involved a racetrack that had been just on the outside of the city, and then went through an annexation process that was very controversial. And then they wanted to do a zone change so they could do some upgrades to the facility, and it just got very, very ugly. The city councilor signed a letter to the editor, including opponents to leave town. They then, well, one of the city councilors called the police chief and requested police logs for any calls or any information they had about the project opponents, met at the mayor's house in the kitchen, went over all of these police logs, then directed the city manager to include those police logs in the record of a land use decision. So there are about 16 different ways that the records show that at least this one city councilor was biased and should not have participated in the decision. But the reason we cite this case is for this. The role of the local government decision maker is not to develop evidence, but to impartially consider the evidence that is submitted to you in the course of the public proceedings. So again, you're the judge. You don't go out and develop your own evidence. You base your decision on the evidence that's presented to you by the advocates for both sides. And this is important because in a time of social media, saturation, for any controversial project, it's hard to stay away from the social media. And so if you go onto Google Maps, for example, to look at the site, an aerial of the site, you are developing your own evidence. You cannot do that. You cannot, if you have, I was talking to a city councilor recently who used to work for Eco Northwest and had reviewed lots and lots of reports for different kinds of development. None of those can be put in the record. The city councilor had relevant experience on how to evaluate the credibility or impartiality of some reports that were submitted, but you cannot bring in outside information bring in outside information when making your decision. Your job is not to develop evidence, but to base your decision on the evidence that's presented to you. Go ahead, Kelly. This is another one that often comes up, this kind of situation. So I've had planning commissioners who were like Boy Scout members, and the Boy Scouts wanted to build a shelter on the property, and it was subject to land use review. In this case involved a city councilor who was a member of the church. The church applied for an additional use permit. And the question was, I mean, this is an organization you're a member of, and they're the applicant. How can you not be biased? And what happened in both of those cases is the decision maker said on the record, just frankly, just addressed the issue, just got it out there and said, look, I'm a member of this church. I understand the issues involved here and why people might be concerned, but I can set all that aside and make a decision based on the evidence in the record and the criteria in our code. And if you make a statement like that, and frankly, I mean, it should be a statement, it should be a truthful statement, Luba will defer to that. Luba takes city councilors, planning commissioners at their word. So in this case, the decision maker had expressed concerns about the condition of approval, but nevertheless declared that she was able to render a decision based on the facts in the law. And Luba concluded based on that she had not prejudged the application, and therefore there was no bias, at least not enough to reverse the decision. The last one I wanted to mention is this Nisita case, mostly because I learned a new acronym when I was researching this. In this one, an opponent challenged the city's decision to approve a plan amendment, zone change, and master plan. And one of the city councilors referred to an opponent as a banana, which I learned is an acronym for build absolutely nothing anywhere near anything. I had not heard that phrase before, so that was a new one on me. Luba said, look, that's not enough to say that to demonstrate the city councilor was biased against opponents or had prejudged the application and denied the appeal based on bias. But be careful about what you say on the record, because it could be interpreted a certain way. When it comes to how you want to respond to concerns about bias, well, sorry, go ahead. I'll come back to that. Ex parte contacts, we get a lot of questions about this. Ex parte contact is any communication outside the record on a matter that's pending before you. So if an application has been submitted, then it's pending before the city. And if it's an application that can come before the planning commission, you should not communicate with people about this except for staff. So there's a number of sort of difficulties here. One of them is what we call type 2 decisions, lower level decisions that are often made by staff. You will never hear about these. But because the city's code allows for a type 2 decision to be allowed to be appealed to the planning commission, it could come before the planning commission, and therefore you should not discuss that application with anyone unless it's on the record. Again, this often comes up in a world of social media where there are Facebook posts about things, where people tweet about things. There are things like site visits, or if you happen to drive by a site that is proposed for development. Luba has concluded that a site visit does qualify under certain circumstances as an ex parte contact. The way to, oh, and by the way, like bias, an undisclosed ex parte communication, if it turns out there was one, Luba will remand the decision immediately, and it doesn't matter what the vote was. So even if it was 7-0, and without that member, it still would have been 6-0, it doesn't matter. Luba will remand it. Whatever the substance of that communication was has to be disclosed on the record, and the decision has to be made all over again. So it's a real problem if there are undisclosed ex parte communications, but this is the easiest, the cheapest insurance in the world. The way to insulate a decision against allegations of ex parte contact is just to disclose everything. If you hear about something on the radio, if somebody happens to pigeonhole you at breakfast or while you're out walking and wants to talk to you about this, my advice is not to. Set up rules on your computer so that if somebody sends you unsolicited email, it automatically goes to staff and they will include it in the record. If you have these ex parte communications, just disclose it at the hearing, and then people can respond to it, and the decision is clear of any then challenge on the basis of ex parte communications. Again, it's the cheapest insurance in the world and insulates the decision against a challenge on that basis. Just disclose the substance of the communication and allow people an opportunity to respond to it. Again, communications with staff, city attorney, folks who are associated with the city, that is not considered ex parte communication. Also, communications with folks before an application is submitted or after the final decision is made are also not considered ex parte communication, because at that point, the matter is not pending before the city.
Chris, just to clarify, is it after the final decision or after the appeal period?
After, I would say after the decision. Okay. And if somebody, it's a good question, because sometimes the city makes a decision and then within a couple of days we realize that there was an error and we have to pull it back and do it again. If there were communications made after the decision was made but before the appeal period ran, those would still be considered ex parte communications. But again, all you have to do to avoid a legal challenge on that basis is to disclose the communication. So there's no reason, I don't think, to avoid ex parte contacts after the decision's made, particularly when you're at the planning commission, because any appeal would go to the city council. Once the planning commission makes its decision, that decision is out of your hands. And so any ex parte contacts you might have aren't going to affect your decision. It's too late. At that point, it's the city council's problem. Go ahead. Conflict of interest. This doesn't come up very often, but I do want to mention it for a couple of reasons. First is the definition of ex parte communication, or sorry, conflict of interest. There are two types, actual conflict and potential conflict of interest. And these are both defined in that statute, ORS 244.020. And there's really only one difference. An actual conflict of interest is when you or a family member, business you own, somebody closely related to you, somebody or something closely related to you, if your decision will result in a what they call private pecuniary benefit or detriment to you, your family member, or your business. If it will unquestionably result in a benefit or detriment to you, then you have an actual conflict of interest. So for example, if you own the property that's the subject of a land use application, you clearly have a conflict of interest and you can't participate. If you have an actual conflict of interest, you can't participate. You have to step down. You can still watch from the audience and participate as a member of the community, but you can't act as a decision maker. A potential conflict of interest is if the decision might result in a financial benefit or detriment to you or a family member or your business. And one of the examples I'm aware of that that came up not too long ago was a planning commissioner works for a building supply company, and they were considering a subdivision. And if the subdivision gets approved and the houses all get built, there would be a demand for building supplies, including the door and window kind of hardware that they sold. And she asked whether that represented a conflict of interest. And I said, at most, it's a potential conflict. So all you have to do with a potential conflict is declare that potential conflict, explain what it is, and then you can participate in the decision. There's nothing about a potential conflict of interest that prohibits you from participating in a decision, provided you declare the potential conflict for the record. But here's the thing about conflict of interest and bias, is that very often it's in the eye of the beholder, right? And the most important thing in my mind is to defend the integrity of our process and the decisions we make. The last thing I would ever want is somebody to feel like the Planning Commission wasn't being transparent, or that the developer was, we were cutting deals with the developer behind doors, or that planning commissioners were acting in their own self-interest. And, it's usually crazy, conspiracy theory stuff. But if you're concerned about the appearance of a conflict or the appearance of bias, and you want to insulate the integrity of the process, just step down. There's no law that says you have to participate in every decision that comes before you. It is an obligation you take on as a planning commissioner, but you also want to protect the integrity of the city's process. So if you're concerned about the optics at any point, you're always free to step down and not participate in a decision, whether it's for a potential conflict of interest or bias or any other reason. Kelly, is there anything you want to add to that?
I don't think so. I was going to ask Chairman Crosby if he had anything over the years. I mean, he's been doing this.
Yeah.
What is it? 25, 28 years, somewhere in there.
Well, I know that on the was helpful. Most people don't understand on the conflict of interest that money has to be involved.
Right.
And we often, people, I can make up an example, like when the Monfoot Club was doing their building. I was a member of the club when it existed here across the street. Some may say, "Oh, that's a conflict of interest. You go to that club." Well, I suppose it could be a negative or a detriment because they take my money every month. But that's just what I've seen as people.
Yeah.
And what a conflict of interest.
Right. And frankly, that represents confusion between conflict of interest and bias. What they're actually saying is you're a member of that club, you're going to be biased in their favor. And the response to that is, okay, I'll step down, or no, I'm not biased. I can set that, any concern I have about that club aside and make my decision based on the evidence and the criteria. So that happens a lot. People will confuse bias with conflict of interest. But again, if you think it rises to the level where it's going to impugn the process, or you personally, you're always free to step down. There's nothing that says you have to participate.
Yeah, I remember when we had the one, we had a commissioner who stepped down because she owned stock in Fred Meyer.
That's another one in under conflict of interest. The example I like to go back to, there was a Metro commissioner named Rod Park who was owned a nursery on the east out by Troutdale. And Metro was considering regulations governing, I think it was riparian buffers or something. And somebody said, well, you're biased because your nursery has an intermittent stream on it. And they actually filed a complaint with the Government Ethics Commission, who oversees these sorts of things. And the Government Ethics Commission has this thing called a class exception. And when the class of people who have that potential conflict of interest is so large, like, oh, I don't know, for example, people who own Fred Meyer stock, that's too large for it to be a conflict of interest. It falls within what they call the class exception. And they ruled the same way in Rod Park's case. They said there are thousands and thousands of people in the Portland metro area who have property with an intermittent stream. So that falls within the class exception. So if you have any questions about whether or not you have a potential conflict of interest, or whether you fall into one of these exceptions, or whether it's something you should be worried about, check with Kelly. If Kelly doesn't know, he'll connect with us.
I mean, they're usually pretty straightforward, but I have run across a few in the last, I don't know, 10 years that have had my head spinning a little bit. So yeah.
Yeah, I mean, I had a city councilor in I think it was Happy Valley a couple years ago who stepped down because his wife worked for a contractor hired by the applicant, right? It was I think she was like worked for David Evans or something, and David Evans was working on the project. So he said, I'm just going to step down to avoid people even thinking that I'm biased. So it does happen on occasion.
The advice I've given to a few commissioners over the years too is, if you really do think there's going to be a perceived sense of bias or conflict of interest, and we know we have a quorum at the meeting, to me, it's always best to step down. I think it just looks better and more transparent to the public as well. That's been my advice a few times. And I think a couple times in the last 10 years, I know at least once where somebody did step down just because of the potential of a perceived conflict of interest. And they just didn't even want to be questioned on it, basically publicly.
Yeah. And I think that's wise. There's more at stake than just, can your lawyer defend the decision? Yes, I can, but we want the public to believe in the decision and believe in the process. And so if it's going to look bad, just step down. So
I did see Commissioner Mayton had his hand raised.
Oh, thanks, Kelly. Chris, I was just going to ask, can you talk about when you declare a conflict or bias, but you're going to stay on, and then the chair goes, ask the public if they object to any commissioner, and what impact that has for us sitting on the dais?
So let me, two things. One, I want to give folks almost like a little script for what to say. If there's a concern about whether you're biased, but you think you can set that aside and make an impartial decision, that's what you should say is, I am capable of making an impartial decision based on the evidence in the record and the criteria in the code. That's what you say in response to an allegation of bias, and LUBA will accept that statement. For potential conflict of interest, you can state the conflict of interest, but similarly say, it's not a conflict of interest, and I can make an objective decision based on the evidence and the criteria in the code, and I will participate. Again, LUBA will accept that statement. The reason that you sometimes ask people to, if they want to challenge a member on either bias, conflict of interest, so on, is so they can raise it or waive it, right? It allows them to preserve that argument for appeal if they want to go that far, right? So you don't have to respond. The only reason that that's part of your hearings process is it gives people the opportunity to raise the issue and preserve it for later, but you're under no obligation to respond. And if you do respond, I would just declare for the record that you can be impartial and make an objective decision.
Thank you.
Anything else? Okay.
I had one other question that came up that you mentioned about, example was going to Google Maps.
Right.
I mean, I have to admit, I've been guilty of that. I'm reading through a staff report and it may mention the property to the west or something, and I want to get a view of it. But you said that was creating my own evidence.
Right. So that you can do that, you just have to tell people you did it, right? Because maybe that picture you're looking at is dated. And somebody could say, yeah, but that was my property. They took that picture last year. Since then, we've done X, Y, and Z. Who knows? You have to, whatever it is that you're looking at that enters your brain and that you might think about when making this decision, people are entitled to know about it so that they can address it if they want to. So, yeah, I mean, that happens all the time. And all you have to do is remember to let people know, okay, I was just looking at this on Google Earth and here's what I saw. That way, if anybody's concerned about it, they can address it. And you have insulated the decision against appeal on that basis. So again, that falls in the category of conflict of, ex parte communications. And the way to fix that problem is just declare it. Just tell everybody what you did and saw.
Okay, so like if a development came in and they had a new design, well, a new roofing material, and I Google that and do some research on the roofing material, that would be ex parte, and I would need to declare that.
That's right. That's right.
Good.
But staff can do all that research and give it to you, and then that wouldn't have to be declared because it would just be part of the record.
We ask the staff to do that, or?
Yeah, I think I mean, it's a really good point you're bringing up, Chairman. And I think if you did have a question about I think you're talking about like a new design element for roofing or something.
Yeah.
Yeah,
something.
I think the best, I do agree. Like if you sent the staff member that's working on it, and then we could look into it and then send something to the entire commission on it. I mean, do you think that would be a good way to handle that, Chris?
I do. And you can often use staff that way to sort of funnel information into the record that you've discovered on your own that you would have to declare if it wasn't already in the record. But if you send Kelly an email saying, hey, I was looking at this new roofing design and I found these photos on Google Earth, then Kelly can put them in the record and it's not ex parte anymore. Once it's in the record, it's not ex parte. So and that way, it also allows everybody else to share in the information and knowledge that you just came up with. That's I often funnel things through staff because once it's in the record, then it's not ex parte.
And can get into the record after you have distributed the staff report.
Correct.
Okay.
Yeah.
I mean, I can, or any of the other planners can put it into the record anytime between when the staff report was published or even up into the meeting.
Right. I think, Kelly, don't you have something in your part script that asks the staff if anything has come in since the staff report was issued?
I'll admit I'm not very good. Jerry's so efficient that I don't ever really give him a script. So
okay.
He takes care of that on his own, to be honest. He leaves me that obligation. So no, but if we do, we try to mention it at the beginning of the staff report that there's additional evidence that's been submitted and is now included in the record. And we usually even try to say what exhibit letters or numbers those are.
So that's how, if it comes in early enough, staff will put it in the staff report. If it comes in later after the staff report goes out, but before the hearing, then it just gets discussed at the hearing itself. But there's always information to funnel stuff into the record. There's always a way to funnel information into the record.
Yeah, Chairman Crosby's been doing this longer than I've been a planner, so he's pretty efficient at coming up with the scripts and running the meeting.
This is excellent learning for us, because I could see where we get a staff report and some idea. So I do go looking on the about the new roofing. So I would notify Kelly
or Emily or Shelley, who's ever
somebody on staff that would look it up maybe print some copies of what I saw. And when we show up at that meeting, it'll be right here. It'll be Exhibit C. And that has put it into the record.
Or, yeah, and we try to even include it as an exhibit and post it to the agenda too. If we have it enough time
But
before
we
the meeting.
Usually only have a week and,
Right.
we're reading the day before or something.
I mean, posting things online have become so easy that
Yeah.
we'll post things up to like 2 or 3 p.m. the day of the meeting if we have them by that time.
Mhm.
And then after that, obviously it's tough, but
And yeah, and that's just I can't say enough how that it makes my job easier. If everything's in the record, then I don't have to deal with these extraneous issues should a decision get appealed. We can focus on the actual application and what was proposed and the substance of the planning commission's decision. So again, if you find information that you think is relevant and you want to talk about at the hearing, just give it to staff and we'll put it in the record. All right, let's move on. I'm starting to run out of material here. I did want to touch on this because with House Bill 2001, Senate Bill 458, Senate Bill 8, House Bill 2006, the legislature has been very, very active in the last about 4 years in legislating local procedures and the substance of local decisions, when you have to allow duplexes, when you have to allow certain kinds of land divisions. I was talking to a mayor the other day who was really, really frustrated that as a result of all of this, in certain contexts, mostly residential, there is very little room left for local discretion when it comes to individual projects. Moreover, all of those state laws now have to be incorporated into your development code. And that's where we get into the world of legislative decisions. Legislative decisions involve the adoption of generally applicable policies and standards and apply to a broad class of people. So for example, House Bill 2001 says you have to allow a duplex on all lots or parcels where single family detached residential development is allowed. Well, that's a big chunk of the city. Right? That's a big chunk of your residentially zoned land. So that is a policy that applies to a broad class of people and properties. So that's be considered a legislative decision. I know you have park amendments coming up. Kelly, I know you've been trying to chase me down about that, and I'll call you as soon as I can. But so we have, changes. A park master plan applies broadly across the city. These are all legislative decisions that determine what you want the city to look like and how you are going to comply with these state laws. But because that's what it is, it's an expression of city policy, the city's identity. You're not required to reach a decision on a legislative proposal. Sorry, I'm trying to read that third bullet point. It wasn't saying what I wanted to say. What it says is true, but I'm making a different point. You're not required to make a decision on a legislative proposal based solely on the criteria in your code. I assume all of you were appointed to the Planning Commission because you have an interest in this stuff. You may have predispositions, things you like, things you don't like. You're allowed to bring all of those to the table and make policy decisions based on what you think is or is not a good idea, provided, of course, it is consistent with state law, state and federal law. That's unlike a quasi-judicial decision where you're limited exclusively to the criteria in the code. Policy decisions are just that. You can make those based on your own idea of what constitutes good policy. You also don't have to reach a decision on a legislative proposal with certain exceptions. For example, House Bill 2001 says you have to adopt your code amendments by June 30 of this year. So in that case, you do kind of have to make a decision by a certain date. But your Parks Master Plan can probably wait, or it can speed up or slow down. You're in control of the timeline. Unlike, again, a quasi-judicial decision. You could table a legislative decision entirely. Again, unlike quasi-judicial. The other thing that's important to understand is bias and ex parte requirements do not apply. You were probably appointed to the Planning Commission because of your bias in favor of or opposed to certain types of development. And again, in a legislative context, you're expected to bring those biases to the table. You're expected to go out and talk to as many people as possible, gather information, because at the end of the day, you want to make what is a good policy decision for the city. So bias and ex parte communications do not apply to a legislative decision. And again, this is going to come up, I don't know, a lot over the next few months, right, Kelly?
Yeah, the other thing that if you want to hit upon is one thing that we just adopted was the Parks Master Plan. We're going to re-adopt it with some amendments. We have the TSP to adopt, and then in a couple of years, we're going to have the comprehensive plan to adopt. So those are legislative decisions as well. I don't know if you want to cover those or say anything else on them.
No, other than what I just said, that you may have some policies or goals in your comprehensive plan that help guide your decision, but you're not expected to be unbiased. You're allowed to have ex parte communications. It's a policy decision. You're bringing your policy judgment to the table. You're not just acting as a judge. Quasi-judicial, different story. But for those kinds of policy decisions, master plans, comprehensive plans, transportation system plans, those are legislative decisions. They affect the city broadly, and you're allowed to make a decision that you think represents the best interests of the city.
Commissioner Hook has his hand raised.
I just had a question about if we're in the legislative process, you maybe expose some of the biases that you have. Let's say you don't like apartments or something else. Is it found that those biases are held against you at some point in the quasi-judicial process?
No.
Maybe.
No,
Okay.
They are not. And I'll give you an example. People will remember those things, right? They know that you're in favor of or opposed to something. There's a case that involved Rob Drake when he was the mayor of Beaverton, and there was a quasi-judicial application that came before them. And it was from a fantasy video, right? Adult store. And he just addressed it head on. He said, I don't like this kind of use. I don't think people want them I don't think we want them in our community. So he declared his bias, but then he went on to say, but I don't get to make that decision tonight, right? This is a quasi-judicial decision, and I have to put on a different hat, and I have to make a decision based on the evidence in the record that's been presented by all these people and the criteria in our code. And that's what I'm going to do. And Luba looked, and his decision was challenged based on bias because he said, I don't like this kind of use. But they said he went on to declare that he could nonetheless be objective and make a decision based on the evidence and the criteria. And Luba said that's good enough. If you think you can set aside your bias and make an impartial decision, Luba will take you at your word. And I don't think you have to be afraid of things you might have said in the past. I like this or I don't like that. And as long as you can just get it out there and address it and be objective when it comes time to make a quasi-judicial decision.
Thank you.
Any other questions?
I had one more and then
Yeah.
just because I think there's some confusion around it. And once in a while, we've been kind of challenged on it and we've always been right, at least in my tenure, but measure 56 notices, can you cover that? And when those need to be sent?
Yeah, so Measure 56 was 1999, and it says that when a city rezones property, you have to send out individual written notice to all affected property owners. So the question becomes, what does it mean to rezone property? And the statute says that property is rezoned when you either change the base zoning classification, so like from residential to commercial or commercial to residential, or you limit or prohibit uses previously allowed in the zone. Limit or prohibit uses previously allowed in the zone. So a recent example is that has come up with in the context of House Bill 2001. You have to change your zoning code now to allow duplexes on every lot or parcel that allows a detached single family structure. That broadens the uses previously allowed in the zone. It does not limit or prohibit anything that was previously allowed in the zone. So it does not require Measure 56 notice. Conversely, a change to your to the height limits in residential zones from 45 feet to 35 feet would limit or prohibit uses previously allowed in zone if you also allow things like churches or cell towers that are taller than that. So for that change, you would have to send out Measure 56 notice to every property owner in the zone, the affected zone. Does that answer your question?
Yeah, we've just been challenged a few times where they said we should have sent one, and
Now, they're going to have to explain how the proposed zone change will limit or prohibit uses previously allowed in the zone.
exactly. And we've been pretty consistent about asking BEH when we do think it's questionable.
So background on that statute was proposed in the 1997 legislative session and did not pass. So the proponents went out and gathered signatures and put it on the ballot where it did pass. And that's why it was not adopted until 1999. But that's when I wrote. So I know that statute very well. The lesson I just want to, especially the new members, want to hammer home is when you get a quasi-judicial application, you can only apply the criteria that are listed in the code, and those will be set forth on the staff report. But that doesn't mean that you're just rubber stamping anything. The criteria often contain words and phrases that can be read in different ways. And similarly, the evidence may or may not persuade you. And if it doesn't persuade you, say, I don't think your traffic study is good because it doesn't evaluate this intersection, or you looked at the wrong times of day, or just because you're limited to the criteria in the code doesn't mean that you're without the ability to exercise judgment. But just make sure that whatever answer you come up with, you can point to why or not you believe the application meets the criteria or does not. And if you don't, you'll have to answer to the chair because he knows this stuff better than anyone. Anything else? All right, thanks everyone. We're here if you need us.
Thank you.
Chairman, would you like Chris to stick around for the bylaws discussion and the director's report, or do you not think it's necessary? I'll leave that up to you.
As soon as I say no, then we'll have a question.
Inevitably.
If I say yes, then he'll feel like he was wasting his time.
You can always have Kelly compile the questions and send them to us if that would be helpful.
I don't know. I don't know of anything on the bylaws, because they'll just get reviewed by him anyway, won't they?
Correct.
Yeah,
Before they go to city council to just make sure there's nothing of issue.
I think we can probably let you go.
Okay, that sounds good. Thanks, everyone. Again, check with Kelly if you have any questions. We'll get back to you. Have a good evening, everyone.
Thank you, Chris.
Thank you.
Yeah, Chris has had a lot of hearings, and he's the city attorney for Happy Valley and a number of other cities
my
as well.
Yeah,
And he's actually had a lot of long nights lately. That's why I was
yeah.
asking that.
Well, good. I appreciate. The learning is great. And to Commissioner Poulin and Commissioner Wegener, a couple terms that just to get you beginning in this learning curve that you will be hearing, it's already been mentioned, is that clear and objective. That's kind of a recent one on our radar. And one that you will hear a lot is that 120-day rule. That'll come up in meetings. We'll ask, where are we at on the 120-day? And you'll see it in some of the staff report because we have to make a decision, and we have to make a decision and give room for appeal within the 120 days. But any other just general comments about that training that you might like to share that might be helpful to others?
Every time we do a training, I'm thankful for it. And every time, even if I'm hearing the same information, I get it in a new way. So it just seems like the learning curve with this never stops. So thank you for providing it.
Yeah, we all learned about ex parte contact on Google Maps. So I did not know that.
That's true.
Sharon, is that, I was gonna ask this and maybe I should have done it before Chris left. Is that when we do a site tour on our own, and I've done that almost every month,
Me too.
that's not anything that you have to disclose in ex parte. If you're just
It is.
driving to the site that's in the meter, you do.
It is. You're supposed to.
Oh,
See, I've never done that.
me too. I've been driving by.
Still learning.
I wonder on that one, if I could speed it up, if I just asked, who has been to the site?
Mhm.
Raise your hand. So
Yeah,
you don't have to respond to the 4 different people saying, yes, I went to the site on Tuesday and this is what.
I agree. I think
Yeah.
that'd be the same thing with the, yes, driving to the site or visiting the site or even driving by the site like on a regular basis, that should be declared. The Google Maps thing was a new one to me too. I was unaware of that before this evening.
yeah. See, I thought the site was only if I got out of the car, walked around and talked to somebody there. But if I just drove by and was checking out the site, visually, I didn't think I needed to disclose that, but I learned something new.
I know one of the phrases in the opening spiel is well, it used to be, I don't see it in this particular one. As I would ask, are you all familiar with the site? That used to be in the old script.
Mhm.
You used to ask that. I remember that.
Mhm.
Well, we will do a better job.
We could coordinate on the script too and kind of make
Mhm.
sure we're hitting, I think, all the major,
Yeah, make it go quick.
I think so.
Very good. Okay, next on our agenda is the director's report. And there was kind of,
Yes, I can kind of walk through a few things on this.
Mhm.
Since I published this only, a week ago or so, the February 22nd meeting, that has kind of changed. We are running into some issues with the consultant not being available, the consultant for the comprehensive plan not being fully available that evening. So they were running into some obstacles with conflicts with other cities they're also presenting in that same evening. So all the 22nd will be at this point will be selection of the Citizen Advisory Committee. The Citizen Advisory Committee, there's an application online right now and we're pushing it out. It was on Facebook. It's going to be next Monday, I believe it will be in the Sandy Source newsletter. It's also on Sandy Speak. So we're asking people to apply. There'll then be a selection committee, and then we will be giving recommendations to City Council for that committee on February 22nd. So you're more than welcome to attend if you'd like to listen in, but it's not going to be the comprehensive plan kickoff meeting that we intended it to be. That has been moved to March 7th. So on March 7th, when you are invited to a joint work session with the City Council to discuss code modifications for Senate Bill 458 and clear and objective modifications for Chapter 17-100. At that same meeting, that's when we'll have the comp plan kickoff with the consultant. So you don't really have to be that involved on the 22nd or even attend if you don't want to. And then the 28th, it's looking like the item that we thought we were going to have on there, which is a pretty big subdivision called the Bornstead Views. It looks like that's likely going to get moved to March. And I let Chair Crosby know about this. So there's a chance you will not have any commitments in February, actually, but then you will have a decently lengthy meeting on March 7th. And because of the nature of the March 28th meeting being Senate Bill 458 plus most likely a subdivision proposal, I would be prepared for both of the March meetings to be lengthy. So yeah, I don't believe at this point we're going to have a planning commission meeting in February, but be prepared for a couple long evenings in March. And then I was just going to go, I wasn't really going to hit upon most of the rest of the information on the first page of the director's report, unless anybody has any questions There's a little update about an addition on Mount Hood Cleaners, the Barnstead Views subdivision, which I was just touching upon, the comprehensive plan, and also Senate Bill 458, which you'll hear a lot more about in March. And what Senate Bill 458 is the follow-up to House Bill 2001. So House Bill 2001, as Mr. Crean just explained, requires cities over 10,000 and less than 25,000 people to have duplexes on any lot that a detached single-family home is allowed on. So we adopted that language last May, and it went into effect in June. And now this is kind of the second part of it, and this basically allows those lots to then be subdivided. So it's not going to remove our minimum lot size requirements, but what it does allow is, say, a duplex is built on a 7,500 square foot lot. They then can come in and subdivide that lot into 2 lots that are both, 3,700 square feet, or they don't even have to be the same size, as Emily will explain in March. So there's not going to be a lot of discretionary ability on the city's behalf, but there are a few points where Planning Commission and City Council will have decision space, and we'll be highlighting those at that work session. So I don't know if anybody has any questions about any of the updates I put on the director's report.
I just had a question about, are you getting very many duplex applications on single residential?
I believe we received our first one in late December for a conversion of a single family home to a duplex. It's actually on a very large lot. So even if they go to subdivide it, it really wouldn't matter. I mean, it's, I don't know if Emily knows how large it is, but I think it's over an acre lot. It's very big. And then what we've heard based on the construction plan submittal for Cedar Creek Heights, which is the subdivision by Johnson RV, most likely half of those lots, so out of 89 lots, half of them are going to be set up so that they can have 2 utility services on each lot. So a water line and a sewer line, electrical lines, everything separated, because we believe they're going to then divide those afterwards once Senate Bill 458 passes. So there could be 40 plus out there potentially. But those are the only ones we've heard so far. So they're kind of different. The one is a conversion, and then the other one is a new subdivision that was approved for 89 single family homes. Potentially half of those lots will be duplexes. And then after that, further divided into smaller lots, essentially. And, that's well within the House bill and the Senate bill.
I just had a comment on that February 22nd meeting, and this is, I guess, mostly for Darren and Breezy, that's a good example of a legislative process. So you had mentioned the Citizen Advisory Committee. So commissioners are able to go out and talk to neighbors and say, hey, consider being on this and so forth. You can talk about that because that is a legislative thing. You don't have to worry about who am I talking to, what do I have to declare and all that. So it's a good example coming right up now with the comprehensive plan that that's where you want to be talking to people.
Yeah, very much so. If you know people that you think would be interested and committed through the 2-year process, I would definitely reach out to them and encourage them to apply.
Mm-hmm.
And then since I don't have any other questions on that, I'm going to jump right into the discussion topic, which I typically don't do for directors' reports, but it's something I was talking to the city manager, Jordan Wheeler, about, and we want to get some advice and input, and then potentially get input from the city council as well. And depending on that input, possibly bring code changes that would remove mini storages from some zones or multiple zones. So maybe just a zone or 2, or maybe multiple zones. So, and the main reason is because we're getting a lot of interest. I think we've had 3 or 4 pre-ups in the last 6 months to a year that have involved large mini storage facilities.
Hmm.
And we're a little bit, I'm totally fine with free market and everything, but we're a little bit concerned because typically, as I put in the staff report, one of the mini storage units that was being proposed was over 250,000 square feet, which is larger than the Fred Meyer building by about 70,000 square feet. So as you can see, they take up large amounts of land. That's about 6-7 acres, right? Plus all the parking and loading and stuff, you're looking at probably 10-15 acres that it would take up. So they're taking up large amounts of land. Typically on these structures, they don't create many or any living wage jobs, maybe 1 or 2 jobs at the most after the construction's done. And then they really have, as we all know, with Sandy Vault that's being constructed right now, they have a very difficult time meeting Sandy style. So they want tons of variances, deviations, and exceptions to our development code. Currently, the use is allowed in 4 zoning districts, which is C1, which is our downtown, general commercial, which is most of the properties along Highway 26 west of our downtown, and then also Johnson RV out on the east. Industrial Park, which is the properties by the movie theater and by where Sandy Vault is going in. By Tractor Supply, for instance, is I-1 Industrial Park. And then light industrial, which is typically in most cities reserved for manufacturing jobs or places where they're actually creating a lot of living wage jobs. So attached to this report is a letter from the economic development manager, David Snyder, that you can read through. That's Exhibit A. There's a lot of cities that are actually looking at legislating mini storages. I know the city of Vancouver has made some modifications to their code to take them out of a lot of the zones or to only allow them up to a certain percentage of the zone, which is a lot of work on staff's part, but just so that this very thing doesn't happen, that basically they run out of industrial lands and then they don't have living wage jobs. And then those people have to commute to other cities where they're putting in factories or whatnot. So there's a lot of good reasoning behind it and why we're wanting to explore it. We currently have 3 facilities. I linked them. And then we have one that's being constructed right now, as I've said a few times. I think that's pretty much all I wanted to say at this point. I will say that the 3 existing facilities would be obviously allowed to remain. And so would the facility that's currently being constructed. And I think if we did decide to remove them from one of the 4 zones or even all 4 zones, we would want to have some non-conforming use language updated to state whether the existing facilities can be expanded. That's typically something you would see just so that they're viable going into the future. So with that, I'll turn it over to Chair Crosby.
Okay. Thank you. Input, opportunity for commissioners to speak, share your thoughts, ideas, things you may have seen.
Commissioner Lee has her hand up.
Commissioner?
Yes, I read the report and I certainly concur with it. We don't have enough jobs as it is, so why limit ourselves even further? And we need businesses that can bring family paying jobs to our community.
Commissioner McLean Wenzel.
Yeah, I would just, I would agree with Commissioner Lee and with the report. I thought it was really helpful, and anything that we can do to limit that kind of use of our land that could be better used to serve our community would be, we should be trying to keep that. So thank you for being ahead of that.
Commissioner Wegener.
Yeah, I agree with what has already been said. I did have a question though. They mentioned mixed use as a possible option for commercial. Do we know, like, is there a percentage of vacancy for commercial space in Sandy right now? I mean, do we have a giant need for it?
Can you expand on that? So
I mean, if let's say we were to not require, we would say, okay, the storage can be used kind of as is right now, versus requiring mixed use or saving it for other commercial uses. Do we need that space for other commercial uses currently, or is there enough vacancy to last us a certain amount of time? Like, is downtown chock full and we need all we can get? Or is there enough room if you have an insurance agency that you can go find a place currently in Sandy and put your business?
I don't think there's that many vacant retail spots currently in town that I'm aware of. There's a few businesses, or not businesses, I'm sorry, buildings in our downtown right now that are vacant. But at least 2 or 3 of those are long-standing holdings that people have had, and they've chosen to take out the previous uses. And at least 2 of those, the buildings have such deficiencies that they can't reopen at this time until they bring them up to current code standards, because they're really dangerous to reopen, actually. So it's a little bit misleading, because a few of our vacant locations in the downtown, they cannot meet fire or building code by any means right now, and that's why they're vacant. I don't think we have a lot of retail space that's available and is vacant, not that I'm aware of. But I think one of the concerns from the city manager's office, and it's also a concern I share, is that if we extend Bell Street and 362nd, like the city is planning on doing for 11 or $12 million, I don't think the city council, and I don't want to really speak on their behalf, but I'm pretty sure that they don't want to see a bunch of mini storages being constructed. I think what they really want to see constructed is living wage job, places that actually have living wage jobs. And there's a little bit of a concern when we get like a pre-app for a 250,000 square foot mini storage facility. That just really starts to eat up our lands, and to expand our UGB and have more commercial industrial lands is a very complicated process that would take years. So it has me a little bit concerned that we're getting so much push for mini storage facilities. I don't know if I answered your question at all.
No, you did, and you gave me the answer I wanted, so thank you.
It's interesting. This is neither a for or against. It's more of an observation as to my guess. Why are there more? Why is there a greater need for storage units? Well, if we think about it, I always tell people that Oregon land use laws, their main principle is more and more houses on less and less dirt. So you've got smaller homes, a lot of apartments, and people who like to accumulate things. And they, you don't have a place to put your snow machine, and you don't, all the Christmas ornaments you got in your front yard. And I'm guessing that's why we got more, our houses have less storage, and therefore there's this need. Now that's just an observation. That's not saying we need to do it, but because I agree with the observations from David and other commissioners that it's very hard to make them look pretty. And it would be nice to see in this process what some other municipalities have done, especially in multi-use ones. I've never seen one. I've seen there's a 2-story one. Is that on Sunnyside? Where have I seen
I think it's
that?
like a 4-story, that new one that they just put in.
Okay, yeah.
It's on Sunnyside, yeah.
All right, yes.
That's one of those very expensive climate controlled ones.
Oh, really?
Yeah, where
Okay.
it's heated and cooled.
But that's what's driving it, my assumption is. And so it's not going to go away. But I agree that we should limit and try and figure out how to limit them.
I mean, one thing I was telling the city managers, I think at the very least, you could try to get them out of these downtown.
Definitely.
I don't know why he was asking why it's even allowed in the downtown. I didn't have a good answer because I don't think that would be a great use in the downtown. Plus, I don't think we'd realistically even get many proposals in the downtown because it's just how big of a building are you going to be able to build? But I don't think we want it in our downtown. And then I really do have issue with it, even the C2, because I do think there'd be concerns or a lot of criticism if after spending $12 million for a road project, we see a bunch of mini storages be developed along it. I don't think, one of the things I was talking to the economic development manager and then also somebody at Clackamas County that does similar work. And one of the things that is trying to be pushed now, and there's a lot of good reason for it, is try to preserve your land for living wage jobs so people can live and work in the community and not have to commute. So for me, I would much rather try to legislate mini storages as much as possible out of our town. You would drive maybe once every quarter to your mini storage 20 miles away, but then you could actually just live and work in the same town. And so I think for like your daily commute purposes, I think that makes a lot more sense to have living wage jobs in town and go to the next town over for your mini storage needs. But that's just my opinion on the matter. There's nothing scientific about it.
Could they be built on rural county property?
They could definitely be built on rural commercial property. And that's where we were trying to convince the Sandy Vault people to move to, only because it's a much cheaper area to build on. The land's cheaper, and then you don't have to build Sandy style. So some of that land out there by like the overpass or the on-ramp to 212 over by like Boring Bark and those commercial. So I believe you could buy a property over there that's zoned commercial in the county land, build your mini storage facility, and obviously the land would be cheaper, and you wouldn't have to build Sandy style. I think some of the pushback from hearing from one of the big developers of mini storage facilities, U-Haul, actually, they're going into the mini storage facility game. And so one of the big things they need is, because the buildings are tall over one story and because they're so large, they have to have a fire suppression system. And because they have to have a fire suppression system, they have to be on municipal water. Otherwise, they're drilling, 20 wells to get the amount of water necessary to extinguish a fire in the event that the mini storage facility goes up in flames. So that's one of the big holdups, I know.
Hollis?
Yeah, so I just wanted to add to the discussion, and especially for our new commissioners, that we've had so much growth in our population and so many new housing developments, especially in the last 10 years. It's just been like constant, that all of those people are going to need places. What we'd rather see is that they have living wage jobs, but also places to eat and shop and do all those things instead of having to drive to Gresham or Portland to get their needs met. It would be much better for the community and for the people who live here, to use our land wisely so that people can get their needs met without having to go somewhere else. So that's kind of at least my thoughts on it. So thanks.
Okay, is that enough on that?
So from what I heard is 3 people were in favor of removal. And then Chairman, you were saying they are hard to meet Sandy style, but you'd kind of like to see more information provided. And then I didn't hear from the other 3 commissioners
And
yet.
I would be in favor of limiting.
Oh, you'd be in favor?
Definitely,
Okay.
definitely, yes.
I don't know.
I'm also in favor of limiting. I just wasn't sure when I was supposed to speak up yet.
And I see that, thank you, Commissioner Poulin. And I see that Commissioner Mayton has his hand raised as well.
Yeah, I echo the same thing that Commissioner Lee and McLean Wenzel said, and the chair and Commissioner Poulin. I'm in favor of limiting. Sorry.
Oh, and Commissioner Hook has his hand raised.
Same here.
Okay. Well, we will start to prepare some code edits and some research on what other municipalities are doing and bring it to a future meeting.
Good. It has our support. Okay, we've got one more thing on tonight's agenda, which is the Planning Commission bylaws. I sent you all an email that had you reference that to 2021-07 resolution of City Council, and I wanted you to see that, so it just gives us the context of where we are. I'm not going to read it, but it's just, as it says, a resolution establishing standard procedures for city boards. And I wake up my mouse here. And the Planning Commission is on that, is in one of these boards. And it mentions several things, but down towards the bottom, section 6, it states that these statutory and advisory boards shall operate under bylaws. And then the bylaws under 6.3, it states 4 specific things that the bylaws are to contain. Now, some of the committees referenced in this resolution have taken the step, because they didn't have any printed bylaws, and they developed their own standalone bylaws. And when we got wind of this and the need that the Planning Commission needed to have bylaws, what we found was that there's already, and now I'm going to go to that myself, there's already sort of bylaws that exist that we have, and that's what you have in chapter 2.16, and that's what you have before you is the proposed edits to chapter 2.16 of Planning Commission, because we have our own section. The other commissions and committees didn't. And so what we had tried to do, and when I say we, as a previous commissioner and myself and Kelly, what we tried to do is take those requirements that were stated that they had to be in the bylaws and somehow get them into this 2.16. So that was the goal. We've looked at this once already, at least 5 of us have. And I'm not sure where to take the conversation from here, other than your observations, comments, questions. Unless Kelly, did you have any?
I did not. The only other thing I was going to add is that we did reach out to, I don't believe I put this in the staff report. We did reach out to the attorney's office, actually not Chris Crane, who was just speaking tonight, but their principal, David Doofman. And he said that all the boards and committees in Sandy should have their own bylaws per that administrative order, but that the Planning Commission, you guys are special. So because the Planning Commission makes actually decisions that can be bigger impacts to property owners, like financially, that he thought it was wiser to keep it within Title II, within the municipal code. And so that our bylaws would just be part of the municipal code, not taken out as a separate document.
Right. That's why we're doing it this way and not having our own separate one. And I'm assuming, I guess the assumption is that City Council will accept them without there being in the word anywhere that says these are bylaws.
I think so. I mean, that's a really good point. But yeah, I think after talking to Mr. Doofman and even our city recorder, these would essentially be our bylaws, even if it doesn't explicitly state it. Yeah, these are your governing laws for your body, essentially.
Mhm. Exactly. I will pause for anybody's comment. Otherwise, I'll just kind of, or next, I'll just kind of work us down through what we have for discussion.
And that was just gonna be my question, Chairman. Are you gonna go through each one, or do you want us to just to pull out what we had questions about?
No, we'll work our way down through each one.
Sounds good.
We won't look at the tiny little ones. But the first one that we'll look at is right there in 216.020 membership. Trying to come up with the wording to describe staggered cohorts was a challenge. And one of the things that triggered this was that 2021-07 established 2 cohorts of 4 and 3 in the planning commission, which meant that theoretically and potentially you could have 4 brand new commissioners coming onto the planning commission in one January. And we didn't like that idea. And we've talked about different things and actually have gone to city council on it, and they have moved towards our proposal here, which is that seat terms shall exist in 3 staggered cohorts of 2, 3, and 2 seats respectively. The seats within each cohort shall share the same term beginning and end dates, which must not duplicate the term beginning and end dates of any other cohort.
Mouthful.
Yes, yes. It's just like, okay. And when I say that they started moving towards that, I guess, I don't know if everybody knows, but we had 4 new commissioners, or 2 new ones and 2 incumbent ones. And city council made Hollis's and my terms to be 2-year terms. And that is to kind of kick off this cohort thing, the sequencing of it. So that's what it would be. There'd be 2 people, 3 people, and 2 people. They all would have 4-year terms once we get into the full cycle, so that we'd never be replacing more than 3 in a given year.
And the seats now are McLean, Wenzel, and Crosby. And then the middle cohort is Mayton, Lee, and Hook. And then the last one is Poulin and Wegener.
Mhm.
So we have 3 cohorts now.
Yep. Questions on there? Is this? I'm not sure if it's clear, but it's as clear as we could get it.
No question, but I just wanted to thank you guys for making this happen. I think it's going to be really good for the, continuity and for transitioning between cohorts. So thank you. And I think for me, the wording makes sense, but maybe that's because I know what it's supposed to mean. So I don't know what other people think.
I think that's what it boils down to, is we all know what we mean and what it's supposed to look like. So the words are kind of secondary.
My question was, does it need to include the length of the term? And also, I mean, should there be some mention of the cohorts being starting 1 year apart? Because as it reads now, I mean, one cohort could start January 1st and the next start January 2nd.
I can answer that. What you have to look at the resolution with this. And we tried not to duplicate anything in the resolution. So the resolution does say under terms, seat terms are 4 years in length, starting on New Year's Day and ending New Year's Eve. So we didn't feel we needed to duplicate that because we still fall under the resolution of 2021-07.
Yeah, and I don't think you could start a second cohort on January 2nd because it wouldn't
Right.
meet the definition in the
it would
resolution.
Violate this.
But it's a really good question.
Yes.
Because without reading the resolution, yeah, it doesn't have enough information.
We just felt that, yeah, it would be nice to have everything in one document, but then we would be repeating, and if one changed, they'd have to change the other one.
Perfect. Thank you.
Would this be a good place to reference that, the resolution?
My opinion is, and it's just my opinion, but my opinion would be no. And the reason is because it seems like city council throws out resolutions often. And there could be another one that would change a little word or two, because 07 threw out another whole section. And the admin 101. So my thought, or where I'm going with this is, if they change something in that resolution and we reference it, then we may have to change our section 2 in a domino effect. So that's just my random thought. Somebody else have a thought on that?
Commissioner Hook has his hand raised.
Okay, Stephen.
My thought was having the seat numbers listed for what cohorts or what, so that it's clear and not just by our names, because this will last longer than we will.
Those do show up somewhere. Where have I seen?
They're on the website, I think.
Yeah, they're on the website, and our numbers are next to our names with our with the dates of our appointment too.
Oh, and by the way, I'm just going to throw this out there since you just mentioned that. I don't know if you all saw, but Rebecca sent an email about pictures if anybody's interested. And so if you want an updated picture, you can definitely do that, and the city's covering it. If you absolutely do not want a different picture, then you can just say no thanks. But just want to remind everybody that
Yeah.
that's out there as well.
I get shot on Friday.
Okay.
I'm going on the 28th, Kelly.
Okay. I just thought I'd throw it out there since we were talking about the website and that page.
I'm on Friday too.
So you're gonna have the beard, Chris?
I trimmed it back, but I'm going to keep it on for this picture. So
Commissioner Hook, did you have your hand still raised?
No, my apologies.
Yeah, that is a new thing, Commissioner Hook, is that we never talked about numbers of our seats in past years. I had to look at the website recently to see if I even had a number, and it just, we weren't thinking that way, but now with this the cohorts and the staggered, it's going to be necessary.
Yeah.
So maybe we should have our number next to our name.
It is on the website.
On video.
Oh,
Yeah, you could. You're number 4, Commissioner Lee.
okay, can we move down? Don't think we need to do anything in the next section. It's just capitalizations and stuff like that. The next big section for explanation 2.16.060 advisory board. In our discussion last time, there was some confusion on what we call advisors, and that's not really what this is. This is referencing an advisory board. So this is not referencing advisors as we call them, is it, Kelly? Is some of the wording does say that or sound like it, but
I don't think so. I think this is, no, I think this is your advisory
yeah, I guess
members.
the question is, if
Your
you only have one
advisors.
advisor, is that a board?
Yeah, I mean, we could change the language to be advisors instead of advisory board. I think that would be more clear.
Yes.
Because I think the second and third sentence are very
Correct.
clear that it's the advisors, but the first sentence is a little odd.
Yeah, that was my question. I was going to call out was that very thing, the word board, and then that very first sentence needs to be completely changed.
I agree.
So you guys got it.
Yeah, so it wouldn't be advisor. It would just say probably advisors.
I think so. I could work with Chairman Crosby to revise that before it goes to
Yeah.
council, if you're comfortable with
And
that.
we've never, the last sentence, I don't know that we've ever had an occasion to need it, but that would be kind of a new thing. Although this text, the text that's in black has been there all along.
Mhm.
They're authorized by city council to have voting power only in the event of a lack of a quorum of appointed planning commissioners.
Yeah, Chairman, when I first applied for planning commission, I think 4 years ago, you told me if I was an advisor, I could vote if there wasn't a quorum. I remember this. So that's,
Mhm.
it's always been there.
Can we, sorry,
Go.
can we call it an advisory committee? With advisors on it and call it a committee so that it's different?
Well, my hesitancy on that is we've often only had one.
Right.
A committee of one.
Yes, and at the most we've had two.
Mhm.
Committee, you tend to think that they meet.
Right.
They would never meet.
In fact, if they did, it could be problematic if then one of them had to sit in if there wasn't a quorum.
Right.
That's-
Okay.
It's okay, they sit in because they were needed for a quorum. And we continue the meeting.
Then I think the next meeting, they need to sit in again and one
Yeah,
of the
the
council,
person
and one of
that-
the commissioners needs to sit out if there's a full commission.
Yeah, yeah. That's
I think you would have to, yeah.
kind of a weird twist.
Yeah, very odd. If you get a continuance.
Like I say, I guess, I don't know how many times that we've ever had to cancel a meeting because we didn't have a quorum.
I think in my 11 years in Sandy, I think one time that I remember,
Yes,
I think there was one time where we only had like 2 or 3 people.
it's very rare.
Yeah, I only remember it once happening in the
Yeah.
last decade.
Okay, so we will work on the text of that one to make it just be advisors. So it's not a board.
Right.
The election of officers in the next is a new section, simple statement that we do what we did now at the first meeting of each calendar year. And that the chair and vice chair have 1-year terms. That's always been our practice. I think this may have been from Admin 101. Because it existed somewhere else.
Yeah, possibly. I don't remember.
Okay. I'm just looking back to the resolution. Procedures for electing board officers is one of the things that have to be in the bylaws. Member qualifications, that's back in the first section.
Yeah, I think the 101 was a little more vague. And I think this is more in line with the past practice for
Mhm.
planning commission. And I don't know if all the boards call them actually chairs and vice chairs. I don't know if that's consistent across all the boards in Sandy, actually. And I know of a few that only have the chair position and not the vice chair.
Mhm. Okay, moving on, I think, let's, raise your hands. The quorum is just,
I had a question, Chair, on that last one. Just from my own recollection, back in, I think November, or not November, October, when we talked about that election of officers, we talked about term limits, like how long somebody can hold that chair, and we talked about rotation for succession planning. Is that not a part of that? I mean, it's not written there, so I'm assuming there was nothing brought up about that.
the thought is that if somebody wasn't wanted, they wouldn't be voted on subsequently. They wouldn't be elected the next year. I know that can be an awkward thing. I will say this, and I'll say it publicly to Hollis, since you're now the vice chair. I do plan to hand the gavel to you, or whoever the vice is going to be, much more frequently. So
Yeah.
you've been forewarned.
Yeah, I was just thinking about succession planning, that's all.
All the
big con-
all the big controversial ones.
Yes, yes.
Yeah, I appreciate that, Jerry. I want to in-depth training from you first. But I kind of agree with Chris in that it's hard when somebody's done the job so well as you have, Jerry, that nobody wants to go in the wake of you because you're so good at it and you've done it for so long. And so then that kind of keeps us from bringing along a new person to get trained. So it seems like, if people have a 4-year term, maybe the natural thing is that they can't go more than 4 years, but maybe we want to say, only a 2-year term in one of those positions, so that you're forcing transitions to occur, because nobody coming in is going to be able to do it as well as the person that's been in the job. So the inclination is to keep having the same person do it. I don't know if I'm saying it any better than I'm trying, but that's what I'm thinking. I'm thinking that, like with you, ever since I've been on, it's like, well, everybody looks at you and goes, well, nobody can do it better than Jerry. But the thing is, then nobody else is getting trained. And so I kind of agree with Chris that as I'm talking through this, maybe a 2-year limit on being chair would keep us fresh and keep new people, in the pipeline and learning how to do it. And I also like your idea of, whoever's not, whoever's in the vice chair does get to do it from time to time, so they're not intimidated.
And not just when the chair is not present. Here's a suggestion. And I will say, I'm not going to be around forever. So, but if we made it 2-year terms, and I don't know how you'd word it, but I know the board of the organization I work for, you can be reelected 2 3-year terms, and then you have to be off the board for 1 year before you can come back on. So I'm thinking something like that, where we do have term limits, but a person would have to sit out just 1 year. That's an arbitrary thing, before they could come back on. What do you think about that?
The city of Fairview has some language around that. And I believe the language also mentioned that could be overruled by the city council if there was no one to take the position during that downtime.
Okay,
Yeah, and I was gonna add, just because I brought it up, I thought, I was thinking more just on the pure succession plan, just because Jerry, you have been around for a long time. And nobody, I clearly enjoy you being up there. That's why I voted for you. But at the same time, we need to teach others how to do that. And I was my opinion would be, because we vote every year, if you have two 1-year terms and then you're off for a year, you could go back on again in your 4th year, hypothetically. I mean, it's because we're voting every year. I would go on the year by year. And then to Stephen's point, or Commissioner Hook, I'm sorry, I would have the city council as an addendum there to say if there's nobody else that they can approve that. So.
okay, so your suggestion was still do 1-year terms. But you can only serve 2 consecutive terms
Correct.
The chair.
as chair and vice chair.
Correct.
It'd be easiest to put them both together. Yeah, okay, so it'd be 2.
What if you were the vice chair for 2 years and then became the chair?
Different position.
Yeah, I would think that it would allow, if you worded it that way, that would be allowable.
Okay. I just want to make sure we word it correctly.
Yeah. Others, does that sound okay, workable? All right. Okay, we'll work on some words there. I like that.
Yeah, I mean, that would just be every 3rd year, there'd be a new chair, is what that means. And that gives continuity for a couple of years and enough time for new people to get onboarded and learn the process. I mean, just from my lens, it feels like it's a good time to try to move up. And then most of those new people are going to try to be vice chair first, I would imagine, and then move into the chair role. So it gives an order of continuity and succession through my lens.
Okay, we'll work on updating that wording. The quorum section is just straightforward. It's what it has been, the majority of the commission. Now what's unclear, well, okay, no, it's not. I was gonna say what's unclear is what if you have somebody, if you only have 6 commissioners because somebody has left town and resigned. But it would still be true because the majority of the commission is now 6. So the majority would still be the same, actually, 4. See what I'm saying is if the commission were to get smaller, the majority, boy, you'd have to get down to 5 before you would drop a majority to 3. And that's not going to happen.
No. I mean, the off chance of 2 people resigning at the same time or something, that'd be
And the city council not
putting
picking up
people in their place right
putting
away.
people
Yeah,
in.
I agree. It could happen, but the chances are really
Right.
low.
Okay, the final section is on attendance, and this is one of the requirements from 2107 is we have to, the bylaws must include meeting attendance requirements. We've never had anything, so this is new wording. We did look at this at the last meeting. And let me just read it so our ears can hear it and see if we got close to what we were thinking at our last meeting. If a commissioner is unable to attend a scheduled meeting, the commissioner must notify the Development Services Director as soon as the commissioner becomes aware attendance is not possible. If a commissioner fails to attend a scheduled planning commission meeting and does not notify the Development Services Director in advance, the absence will be classified as unexcused. If a commissioner is absent, excused or unexcused for 50% of planning commission meetings within any 6-month period, the matter will be referred to the city council to address.
And I think that last sentence is very important because even though, say, somebody missed 3 out of 6 meetings in a 6-month period and we referred them to city council, I think it does matter if those are like excused legitimate absences or just people just not showing up and not letting anybody know that they're going to be there or not.
Right.
So I think it's an important distinction. It's one thing if you have a planned vacation or an illness or something, and another thing if you're just not communicating and
Yeah.
not showing up.
Yep. Yep. Slacking off.
Yeah.
And this is written such that city council could do what they want. Or they could interview the person and determine that they're okay with that, the absences, and move on. They could remove the person. They could. We didn't want to, original one had a little bit more teeth into it, is what city council had to do. And we decided when we met last time to just have it say, let them take care of it.
And just so you know, I would not refer anybody to city council until I talk to the chair. So if somebody did have 3 excused absences within a 6-month period, I would just let Jerry know, well, according to our, matrix here, and then we would decide if it needs to be referred or not.
Mhm.
Because I think if they were legitimate reasons, I would not want to do that to somebody,
Right.
like illness, say.
Mhm. Mhm.
So it's going to be a judgment call on staff and the chairman's position, I think.
Right. Because we can just,
But if they're partying in Cabo every month, then we'll probably have to refer.
mhm. But in the extent, like the scenario you mentioned with, extenuating illnesses, we can still just refer it to city council and say, we're referring this to you because our bylaws state it, but we're okay with it. And we've talked about it. And because I would think before, even you mentioned talking to the chair, that I would want to get some feedback from others before we do it. And I certainly, or the chair certainly should have been talking to the individual, probably after the second one.
Right. I do see a couple hands raised if you want me to go.
Okay, yes, call them.
Commissioner Mayton.
Yeah, I just was curious about, is that your actual title, Kelly? Because I thought it was planning director, but maybe I was all wrong all along.
That's my title.
Okay, that's all I was asking. Sorry, I didn't know that.
Anyway,
Yeah, it's been my title for about 3.5, 4 years.
And I just thought I thought it was planning director. I'm sorry.
So did I.
Commissioner Lee.
I was just going to say that when I was on the council, we had somebody that missed 3 meetings without an excuse, and the council just voted to get rid of them because they never made any contact.
Oh, is this the council member?
Yeah,
Okay, I remember this individual. Yeah.
well, this is
Didn't-
written that we'd have council do our dirty work for us.
In that instance, though, Commissioner Lee, didn't that person only attend like 1 or 2 meetings before doing that as well?
yeah, I think she only attended 1 meeting and then never came back.
That was kind of odd.
Yes, definitely. Any other hands on this paragraph? Otherwise it would stay.
I don't see any other raised.
Okay. So we're going to do some work on the election of officers paragraph and on the advisory board paragraph and make that closer to reality. And I think that was it.
And then we'll have it reviewed by the attorney's office before
Mhm.
forwarding it.
Do we need a motion for that, or?
It's not gonna hurt.
Yeah. Let's go ahead and we'll entertain a motion to accept the edit. Let me see. Does somebody want to try and come up with a motion before I do? Nobody's jumping. Well, it would be just a motion to accept the edits, proposed edits to chapter 216. Sending it back to staff for the further edits that we discussed.
That I motion what Jerry just said.
I'll second.
Hey, the motion has been made and seconded what Jerry just said. Did you get that, Emily?
She looks tired over there.
I'm typing as fast as I can.
Maybe you should say it again.
That we approve the edits to chapter 216 with staff, allowing staff to make the corrections that we discussed. Further edits, corrections, however. Okay, motion's been made and seconded. All in favor, give us a thumbs up. And okay, Stephen put his camera on. There we go. All right. Thank you very much. One final thing on the agenda. That was a hint for somebody to look at it and adjourn it.
Oh, I move that we adjourn the meeting.
I second that.
And moved and seconded that we adjourn at 8:56, out of here by 9 o'clock. All in favor, I'm sure. We see nothing but thumbs. Thank you very much. It's been a good meeting. It's been quiet and lonely here in council chambers.
Oh, Jerry, you said you wanted to talk about that, but you never did.
Talk about what?
About hybrid.
Did I say? What did I?
At the beginning of the meeting, you said you wanted to talk about the hybrid meeting.
Oh, well, I can't remember now what I was thinking. That was 2 hours ago.
Oh, well, but I thought you were going to try to get us to come in.
No. I've actually just my own personal thing. It's although this is the longest I've worn a mask in a long time. And I'm really looking forward to stepping out that back door. Breathe in that nice fresh cold air. But I've actually, for myself, I've appreciated this better. I've laid out better. I don't have to worry about that. But I'm disappointed that I don't see when you raise your hands.
Okay.
Yeah, we can try to figure that out.
And the other thing is I'm going back and forth. I don't get to look straight ahead, but as you all said, I'm so tiny in the image anyway. It doesn't matter which.
Yeah, we can't see you, but we can hear you, sir.
And I don't think there's any expectation or necessity to be in attendance in person unless you feel like you want to be.
Right.
It was requested that we start doing hybrid so that if there's members of the public that want to attend, that they can. So we'll continue to do that, but I don't think there was any intention on putting any pressure on volunteers to come into the council chambers.
Very good then, everyone. You are
All right.
to end the meeting.
Have a good night.
Good night, everyone. Thank you.